All rise. District Court is now in session. Honorable Judge Hickler presiding.
Be seated. All right. Good afternoon. This is State v. Kohberger. I want to go over the appearances this afternoon on behalf of the state. Would state attorneys please represent themselves for the record?
Thank you, Your Honor. My name is Bill Thompson. I'm the Latah County Prosecutor. This is Ashley Jennings. She's my senior deputy. And then we have Mr. Nye and Ms. Beatty from the Attorney General's office. And then we have victim support staff with us.
All right. Thank you.
Yes, sir.
Defense?
Ann Taylor, attorney for Bryan Kohberger, Elisa Massa, and Jay Logston, counsel for Mr. Kohberger as well.
Thank you. All right. I'd like to tell you I'm happy to be here, but why start with an untruth? I am accepting of my responsibility to be here. I want to go over with you some expectations of mine, given that I don't think any of you, other than Ms. Massoth, have appeared in front of me before. When you file memorandums of law, briefs, et cetera, please provide a Word copy by email to my staff attorney. After today's hearing, you may get that from staff here today. Today, I know there was an issue that was brought up with respect to Mr. Kohberger's attire for today. I did issue an order yesterday permitting him to appear in civilian clothes for this hearing only. That is a matter in terms of future hearings that we will take up in a closed hearing the day of, but in advance of whatever our next hearing date will be. My intention will be that Mr. Kohberger will not be present for that hearing because part of what we will be discussing are security measures, and I expect to hear from the transport deputies and the bailiffs regarding security issues that they want to address or that I have questions for them about, so that I can make an appropriate ruling in terms of his appearance here, but weighing that not just against, of course, his rights, but also against the needs of security in this case. I do expect, as it probably will come to no surprise to you, for you all to get along. I understand the stakes in this case are as high as they can possibly be in any case, but you are professionals. You have taken oaths, both as of officers within your jurisdictions, but also as attorneys before this bar. So I expect at all times for you to remain civil to one another, that you not engage in personal attacks, ad hominem attacks, that you not engage in theatrics, not misstate the facts or the law to the court, and that when you cite arguments in your briefs, if there is contradictory precedent, I expect to see that. I appreciate in advance what should go without saying that I've just said in terms of your responsibilities, but again, I just want to highlight that because I understand when the stakes are high, sometimes victory seems to be the objective when our first objective is to conform to the oaths that we've taken as members of the bar, as officers of this court. All right. I do have some matters with respect to scheduling that I want to go over today, but before I do that, I'd like to hear from you with respect to the matters that you either need to make me aware of or want to make me aware of. The other thing before I do that, though, I do know that Judge Judge had entered a non-dissemination order. That still remains in place. And unless I, for some reason, remove that order, it will stay in place, and I expect it to be religiously adhered to by all parties, counsel, victims, counsel for the victims, and I will not tolerate violations of that. Likewise, I know that much of the evidence in this case has been subject to orders sealing under that dissemination order or otherwise have been sealed by the court. I likewise expect everyone that has access to that information, whether it's sealed documents or information in sealed hearings or the information itself in the documents, to adhere to the confidentiality expected as it relates to those. Okay, that's my one and only lecture for you for the remainder of this case. With that, let me hear from you. We'll start with counsel for the state.
Your Honor, I don't know that we have specific questions we want to propose today. We're looking forward to hearing the scheduling. I think that's going to drive, for us, particularly the distance involved, any questions that we may have. I appreciate what you've already mentioned to us, and we will certainly honor all of that. Thank you, sir.
Taylor?
Thank you, Your Honor. There are a few issues that I wanted to make the court aware of as the court decides on the scheduling order. We want the court to know that our team has been working towards the June of 2025 trial date that had been issued by Judge Judge in the case. But in candor to the court, I need to let the court know some issues that have come up that we face that causes me concern. First, I think the court's probably aware of the vast amount of discovery that's been exchanged in the case by reviewing the record. But since August, we have received about 398 gigabytes of new information, and I can tell the court that nobody on the team has read every bit of that yet. So there's a vast amount of discovery to continue to go through, and I wanted the court to be aware of that. The second thing is that during the course of this case, we had an expert that we were working with, and that expert passed away. We have been able to refill that role, to have a new expert to do the work that that expert was hired to do, but we are not progressed to the point that I'd hoped to be through no fault of the new expert. The court should be aware of that as well. And last, as the court is very well aware, the system of delivering public defense is changing next week. As appointed counsel in the case, I do not have a contract yet. Nobody on my team is under contract for this case. I'm concerned about what that means, and I thought the court should be aware. Further, we have been able to access funding to help us prepare this case through Idaho Criminal Rule 12.2. At the current time, we're working with about 25 experts and investigators to prepare the case. I don't know if 12.2 will continue to be the way to get funding for those experts and investigators, or if that's changing. And I thought the court should know those things. Thank you.
Thank you. So I am hopeful that Mr. Fredrickson will ensure that a contract is available for you and your team next week. I have no control over that, of course, other than to, as it relates to who I permit to withdraw from this case or not withdraw from this case. As to 12.2 funding, my understanding is, and I've had a discussion with Judge Munson, who has been serving, as I understand it, as what we refer to as the money judge. I've asked him to remain in that capacity at least through the transition to the state public defense system in next week on October 1. My understanding is, and perhaps I will come to find out something different, but that once it goes to that system, 12.2, as it relates to public defense funded attorneys on contract seeking 12.2 funding, that's no longer a thing, that would come through the state public defense budget essentially. I guess we'll find out if that becomes a problem down the road, but that's my understanding, because that whole system that 12.2 is based upon is coming to an end. So, given your statement about the trial date, my proposal to move this case forward into May is probably not going to land well with you, but that's what I wanted to talk about, is the timing of the trial. I'm concerned with a trial as currently set for a number of reasons, but first I want to find out from you, as you sit here today, what that trial looks like in terms of the number of weeks of trial, starting from after a jury is selected through the end of the evidence and before any potential sentencing phase. So what are your estimates of that?
Your Honor, I think it would be a fair estimate based on what we know at this point to have a month and a half or perhaps a bit more just for the evidence for the guilt phase of the trial. I say that knowing,
Is that just your evidence, or does that include defense evidence?
well, I was just getting ready to say, I say that understanding or acknowledging that Ms. Taylor has estimated 2 to 3 months total. I do not know, we do not know what the defense has in mind for their case right now, so all I can speak to is what we anticipate for ourselves. But I would think the state's evidence in chief should be able to come in a month and a half or so.
Okay. Ms. Taylor?
Your Honor, we estimate 4 weeks for the defense portion of the trial case.
Of the guilt phase?
Yes, Your Honor.
So 10 weeks. In terms of if there is a penalty phase, should the defendant be convicted of one of the statutory qualifying offenses, how long do we estimate the penalty phase being?
Your Honor, from the state's perspective, I believe we're going to be relying heavily on the evidence that's introduced during the guilt phase, and that the additional evidence that would be brought in, unless there's something we learned from the defense about their experts, is probably would take no more than a week.
Taylor?
Your Honor, I would estimate 2 weeks for that part of any trial,
That's
for our evidence.
For your evidence?
Yes.
Okay. So my concern, because this trial is currently set to begin June 2nd and end approximately August 31st, is having it set to run the entire course of the summer, I think we will find to be difficult on jurors in particular. Jurors who may have children who are out of school in terms of being able to spend time, go on vacations with them, et cetera. That's one concern. The second concern is with school that typically starts in mid to late August, and jurors or parents who may have kids going off to school, the timing of that through August. And that's my primary concern about that time frame. I had 2 proposals. One was to start the trial in the evidence portion of the trial the first week of May, and the other would be to start the evidence in early September. And I'd like your thoughts on those. I'm not saying or necessarily will vacate the June trial date, but I want to look at alternatives here because I am concerned about that spread that takes the entirety of the summer.
And we hear you, Your Honor. By way of history, the summer, we advocated for that in Latah County because the courthouse is right across from the high school and the summer would have the students gone. If we were looking at the other 2 choices, we would propose May.
Taylor?
Thank you, Your Honor. Your Honor, I would have to advocate for September at this point, based on the 3 reasons that I gave the court before.
So I'm not going to worry about the public defense change because I think that will take care of itself. The one thing that you brought up the most, I mean, I understand there's a lot of evidence, but, you know, May is not tomorrow. May is many months away. So the one that concerns me that you brought up is your expert. And I'm not asking you necessarily to give away any secrets prematurely that you may have in terms of defense strategy, but can you help me understand this expert, if you're able to, and what their role is and what the prospects are?
Your Honor, it's really difficult to tell you much about the expert without giving away a lot. I can tell you that this is a very necessary expert for us to have on board. We've been able to find somebody to fill the role. I'm confident in the person that will fill the role. There just hasn't been enough time to get the work accomplished yet. I know that that doesn't tell the court a whole lot more than what I said before, but I really feel that that would disclose too much for me to say more. I could do so on an ex parte basis or with Judge Monson, our resource judge, but not in a public setting.
I understand. Do you anticipate being able to fulfill your obligations for your current expert disclosure deadline that was set by Judge?
No, not with a lot of confidence. I think that the work is going to take longer than to meet that deadline. I think if we met that deadline, I would have additional information that I would want to be able to present, and maybe I would have been stopped from that with that deadline.
So I don't have a motion to extend that date, obviously, and with the changes that occurred, I understand why you didn't file one out of the box, but the deadline, I think, is January 6th, something like that, if I'm not mistaken, for experts on the defense side.
That's one of our deadlines, Your Honor, yes.
I guess, does the state have anything to say in response?
Not knowing the details of the challenges Ms. Taylor and her team are facing, I don't really know how to respond further, Your Honor.
What do you think is a realistic deadline for you to be able to disclose your experts for everything? I'm assuming it was January, all save that one expert. But with respect to the expert you had to replace, when do you think you could disclose consistent with the scheduling order?
Other than the expert that had to be replaced, Your Honor, there were 2 separate deadlines. One was for trial experts and one was for mitigation experts. And I believe that I can make that deadline other than that one expert.
Can you tell me if the one expert is a mitigation or a trial expert?
A mitigation expert, Your Honor.
And what do you think you need for that mitigation expert in terms of a deadline? That mitigation deadline was,
I believe it was March. I don't recall the exact date.
yeah, so that's a long time from now. So, I have a lot of questions, but I'm hesitant to ask you the questions because I'm sure you're not in a position to answer them currently. given the forum. So, but March is a long time from now.
Your Honor, the time passes very rapidly, and I appreciate the court not asking questions I can't answer. I think if I had an end of April deadline for that one witness, I think we could make that deadline.
So, understanding this is a mitigation expert, Thompson, how concerned are you about getting that disclosure closer to trial?
Closer to trial is somewhat relative. The end of April sounds like it would be on the eve of trial from the date the court is proposing. I think that would be, I'm not sure that would be realistic. And again, I'm not in a position to second guess
Sure.
what Ms. Taylor and her team are representing to the court. She had told us some time back that one of her experts had some health issues, and I think that she did tell us that that person had passed away and they were working on a replacement. If we are looking at a mitigation disclosure at the end of April, I don't know that we could be ready with all the final trial preparation for a May trial. I hate to say that. I feel like I'm cutting my own throat in a sense, but that's realistic.
Well, I can do one of two things. I can set a separate hearing ex parte to explore this further, but I frankly don't know how far that's going to get me. I mean, I can set a date, and my experience tells me that date will be complied with regardless, right? 24 hours in a day, but if you use enough of those hours, enough days in a row, you get it done if you have to. At the same time, I don't want to put unrealistic deadlines. And so I can do that. I can have an ex parte hearing, or we can go ahead and reserve September. I will throw it to you, Mr. Thompson, is what you want, what you would advocate for.
Your Honor, could I have just a moment? Your Honor, we would trust the court to do the ex parte hearing, see what's there, and make the best decision, and tell us what the expectations are.
Well, do you want to do that later today, or do you want to do it tomorrow? You need more time? You want to come back next week?
Your Honor, I had planned to leave town today. I have other case-related obligations tomorrow. I could do it as soon as this hearing's over if the court has time, or I can come back next week at the court's convenience.
I think we'll probably be finished in here by 3 if we were to do it immediately after. Are you comfortable with that? Does that give you enough time to get to the airport?
Yes, I believe it will, Your Honor.
All right, well, we'll give that a shot. All right. If I move this one way or the other, I will adjust the various deadlines that are in here. I won't adjust the next deadline that you have, understanding that you may be already committed to it, which I think is the motions related to the defense's motion regarding the death penalty, if I'm not mistaken. Is that the next set of hearings that we have?
Those are now scheduled.
I believe that our briefs are due the 10th of next month, with the hearing later this fall and a reply brief deadline for the defense. And we are on track to meet those deadlines, Your Honor.
I'm sorry, you were saying, counsel?
Your Honor, I'm guessing the court has received our motions already. I believe we were set for November the 7th.
I think the state's deadline for discovery has passed. Has the state complied with its discovery obligations, including those outlined in Judge's last order and other orders?
We have, Your Honor, and in fact, Ms. Jennings prepared a lengthy summary of all the discovery that was filed with the Latah County Court when our discovery deadline hit. It is lengthy, but there's a lot of discovery.
Sure.
We recognize
How
that.
much of the, would you say, 300 gigabytes?
398 since August 13th.
How much of that is new information?
Ms. Jennings could speak to that.
Ms. Jennings, can you speak to that?
Your Honor, the defense was given, and I'm not sure if this is what they're referencing, but they were given a copy of the OneDrive from the FBI. Most of that was cumulative discovery that they had already received in another fashion. I'm sure there were portions of it that was new information. I've not calculated how much of that was new. So I can only rely on Ms. Taylor's, what she's represented to the court on that.
Well, I don't think she knows because it doesn't sound like she's looked at it yet.
Not all of it, Judge.
Okay. All right. Well, I will talk when we're finished here with Ms. Taylor without the state present in a closed hearing. What else do we need to talk about today, or do you want to talk about today?
Nothing comes to mind right now, Judge. I know that there will be plenty of opportunity for other discussions. As far as your meeting with defense ex parte, do you want the state for any reason to stay around, or would you like us to get on the road back to Moscow?
Are you flying or driving?
Driving.
Okay. Well, why don't you hang around just in case we need to, if I'm able to make a decision based on that, I can inform you what that is at least.
Yes, sir. Thank you.
Anything further, other than your your motions regarding the death penalty? Do you have any outstanding motions and the motion as it relates to Mr. Kohberger's attire?
Your Honor, there's no outstanding motions right now. I do anticipate filing several motions in the motion to compel deadline. As far as discovery goes, I anticipate there may be some follow-up motions. I, of course, will first try to speak with the prosecutor to resolve those.
Right. I think you will find I'm probably more inclined to hear things more quickly than you're perhaps accustomed to in this case. So just be aware of that. It'd probably be more along the usual, 14-day timeline with respect to motions. If there's a lot that needs to be done with respect to them, we can talk about that, but, okay.
On that point, Your Honor, as you can see, they're a multifaceted team. And on motions, we try to assign them to specific attorneys. On various motions, would it be acceptable to the court for those attorneys who are not actively arguing the motions to be able to participate remotely? Or would you like us to be present? We're happy to do either.
I'm fine with that. I just prefer those that are going to be arguing to be here, just because it makes it easier to have that dialogue, so.
Okay, thank you.
The others, if they want to appear remotely, that's fine.
Thank you.
And same for defense as well, depending on what defense wants to do. Okay. All right. Then if there's nothing else this morning or this afternoon, I guess we will be adjourned and have a discussion in a few minutes. All right?